Dear viewers, welcome to yet another episode on course of property law. I Dr. Vijeta Singh from Assessmania Law College, Jalgaon, Maharashtra. Today we are going to discuss the concept of lease under the immovable property. Friends, let us start with the introduction. Introduction consists lease of an immovable properties. It can provide some benefits like low initial payments, tax reduction, low risk, etc. In a simple term, we can understand that lease is simply the relationship between the landlord, landowner, he or she, and the tenants. Lease is a form of contract between these parties. For a fixed period of a time, this relationship between the owner and their tenant arises. The owner of the immovable property gives his property to another person for a fixed period of time, and a contract was made between them is exactly a lease. Thus, this contract induces the term like amount, that is the rent, rate at which it is collected, duration of lease, purpose of lease, etc. Lease is a transfer of an interest in the property for a stipulated period of time without transferring the ownership of the property. In a lease, right of possession is transferred instead of the right of ownership. Lease of immovable property is governed by Transfer of Property Act 1882 and it is given under section 105 to 117 of the same act. Friends, let us see how it is going to be defined. According to Mullah, a lease is a contract between the lessor and the lessee for the possession and the profits of a land, etc. Section 105 of the Transfer of Property Act 1882 gives the definition for lease, lessor, lessee, premium and rent. It defines that a lease of immovable property is a transfer of right to enjoy such property made for a certain time, express or implied, or in perpetuity, in consideration of a price paid or promised, or of money, a share of crops, service, or any other thing of a value to be rendered periodically or on a specific occasion to the transfer by the transferee who accepts the transfer on such terms. For entering into the lease agreement, there must be two persons, namely lessor and lessee. Then let us see who is lessor. Lessor is a person who lease or let out a property to another person. In simple terms, the transferor is known as a lessor, that is the landlord of a property. Then question comes, who is a lessee? Lessee is a person who holds a lease of a property, means transferee of a lease. Basically, the tenant is a lessee. Now, what is premium? Premium is an amount to be paid. What is rent? Rent refers to the benefits, regular payments to his landlord for using his property or land. Friends, let us have a glance over the essential elements of lease. What is required to constitute a lease? The parties. There must be at least two parties. The transfer of right to enjoy immovable property. Duration, term of the lease. Subject matter of a lease. And consideration. Then who are the parties? The first essential element. There are two parties of the lease, lessor and lessee. Both the parties who executes the lease must be competent to contract. What is the ground for competency? They must be lawfully competent by age, by majority, by their mental capacity, and they should have their own property. The lessor and the lessee cannot be the same person. The lessor can be an absolute owner of the land or a joint tenant or a lessee himself, but he must have attained the majority and be competent to contract. A transfer by way of lease must be made by a person who owns the interest which is to be transferred. Transfer of right to enjoy immovable property. Lease is a transfer of a right of enjoyment. In an immovable property, it is not a transfer of ownership, it is a transfer of partial interest. Where there is no transfer of an interest, there is exactly no lease. Property being leased out must be defined and ascertainable. Duration, the term of lease, is one of the essential component. A duration and the term of lease, the period for which the right to use the property is transferred, is called the term of the lease. The term may be any period of a time, longer or shorter, or even for perpetuity, but it has to be mentioned in the deed. A lease which is silent as to duration of the term would be void. In the case of Macaulay Engineering Works Private Limited versus Dalhousie Properties Limited, the court held that for creating a legally binding lease agreement, one of the most essential elements required is that there must be a definite period, unless it is a lease of perpetuity. Perpetuity means forever. Subject matter of lease. The subject matter of lease must be immovable property defined as per section 3 of Transfer of Property Act 1882. What is consideration? Consideration is the contract of lease must be supported with some consideration. Consideration, either the premium or the rent. So, there must be a consideration fixed for the lease that may be in the form of money or money's worth, such as share in the crops or any valuable, that is service or any other thing of a value, to be rendered periodically or on specified occasions to the transferor by the transferee. Now, question comes, how is a lease executed? Friends, section 107 states about lease how made. This section covers three aspects. The very first, when there is a lease of immovable property for a term of 1 year or more. This can only made by a registered deed. All other lease of immovable property can be either made by registered deed or an oral agreement or the settlement, along with the transfer of possession of that property. When the lease is of multiple properties that required multiple deeds, it will be made by both the parties of the lease. In the case of Punjab National Bank versus Ganga Narayan Kapoor, the court held that if the lease is done through an oral agreement, then the provision of a section 106 will apply according to section 106 of Transfer of Property Act 1882. If there is an absence of a written contract or a local usage to the contrary, then in the case a lease of immovable property for manufacturing and agriculture purpose will be valid till the time until it was terminated by either of the party by 6 months notice, and if there is a lease any other purpose except agriculture or manufacturing, then it will be terminated by 15 days notice. What is notice to quit and what happens after it? Notice to quit is a formal written statement that is issued to the lessee if the lessor desires to end the lease agreement, whether on the expiry of the duration as stated under section 106 or on grounds specified in section 111. Any lease can be forfeited as mentioned in the subclause G of section 111 by acceptance of the notice to quit. But section 112 states that if the lessor, after initiating the process of termination of the lease on the ground of forfeiture, accepts any rent from the lessee, it will be understood that the lease will still exist and the termination and notice to quit has been waived. Section 113 provides two ways in which the notice can be waived, that is, expressly or impliedly. Express waive of notice to quit. When a lessor accepts the rent from the lessee after the notice to quit has been served, this is called express waiver of notice to quit. Implied waiver of notice to quit. When a lessor issues notice to quit to the lessee and upon expiry of that notice, lessor issues another notice to quit to the lessee, the first notice to the quit is impliedly waived. Waiver of notice also shows the intention to continue the existing lease. The effects of holding over. Section 116 states about the effects of holding over lays down that if there has been a waiver of notice to quit, it will not be called a new lease. Instead, it will be called as a lease on sufficient or tolerance without objecting against it. The term holding over stands for retained possession of a property which has been leased. After this, the lease is renewable as any normal lease and in the way prescribes in the section 106. This section provides that if the lessor agrees to the holding over the property by the lessee, it will be renewed, but if the lessor does not retain the retained possession by the lessee, he can initiate suit proceedings against him on the ground of trespass or tenant at sufficiency. In Padmanabham Pillai versus Sankaran Vishwambharam, the court held that if lessor receives rent from the lessee and is protected by the Rent Acts, then a new tenancy is not created under this section. Here, mere acceptance would not amount to assent of the lessor about the new tenancy. The lessor must have independent evidence of assent. Now, let us see how many types of lease are available under Indian property law. So, friends, there are definitely two types: absolute lease and derivative lease, which is also known as a sublease. Absolute lease. An absolute lease is granted by a person who has an absolute right over the property. It can be granted for any number of years or for any time. For instance, A is the owner of a house and grants a lease of it to B. for a period of 20 years. This will be an instance of absolute lease. Then what is derivative lease or the sublease? A derivative lease or the sublease is granted by a person who himself has a limited interest in property. A sublease can be granted by a lessee, such as lease is generally known as a sublease. This kind of lease can never extend beyond the time of period for which the primary or original lease was executed in favor of the lessee. In the case of Roop Kumar versus Mohan Thedani, it was held that a tenant who himself does not have a complete right over the property can never grant a valid sublease in favor of another person. In case of Love Rajkumar versus Daya Shankar, the court explained that a person who himself has no right over the property cannot create a lease on his own. Now, we are moving towards the classification of lease from the point of view of its duration. Kinds of tenancies: lease for the fixed term, periodic lease, lease in perpetuity, which is permanent lease, tenancy at will. Lease for a fixed term: a tenancy for a term of an years, where the duration of a tenancy is a specific time period, such as 3 years or 5 years or 10 years. It is a lease for a fixed term. In the case of Lord Keon, in Goodnight D. Hall versus Richardson, the court stated that the certainty need not ascertain at the time. If in the fluxion of a time, a day will arrive which will make it certain, that is sufficient for such a lease. Moving ahead, periodic lease. Periodic lease are tenancies from year to year or month to month or even week to week. They are the kind of leases referred in section 108 as leases of an uncertain duration. It means a tenancy of uncertain duration which can be put an end to by either party by giving 1 month notice. In the case of S. Rajiv Singh versus Punching Associates, periodic leases has been defined as it is a lease with the duration to the term is continuous from period to period. A lease for an indefinite period has generally been considered as a lease for a life, but if the tenant has been paid yearly, then it would be taken as a lease from year to year. Similarly, in the case of Venkatachalam versus Odeon case, it was held that the lease for the year with the precondition, then it would be force until another lease is granted, is a lease from year to year. Lease in the perpetuity, permanent lease. A lease without a term is a permanent lease. In the Indian scenario, leases in the perpetuity are granted with respect to the agricultural property. A fixed rent indicates permanency, but permanency does not necessarily imply both fixity of a rent and fixity of a occupation. The question whether lease is a permanent one or not is one of the construction on the facts and circumstances of each case. In the case of Commissioner of Income Tax, Assam versus Panbari Tea Corporation Limited, it was held that when the interest of the lessor was parted for a price, then the paid price is the premium, but the periodical payment for the enjoyment of the benefit is a rent. Here, the premium is a capital income and rent is a revenue receipt. For this, lease of perpetuity registration is mandatory. Now, tenancy at will. A tenancy at will is a tenancy which can be terminated at the will, either the lessor or the lessee. A tenancy terminable at any time on 15 days notice is a tenancy at will. No registration is required. Now, question comes, how lease can be made? According to section 107 of the Transfer of Property Act 1882, a lease can be made if there is a lease of immovable property for a year or for a term which may be exceeding 1 year or many be reserving a rent for a year, then it can be made only by the registered instrument. So, after registration of lease, after creation of lease, what is mandatory thing? What we need to see? Friends, here we need to focus rights and liability of lessor and lessee. Section 108 of Transfer of Property Act talk about rights of the lessor. What are the rights of lessor? First, a lessor will have a right to recover its rent from the property which is leased by him. Second, lessor having a right to take back his property's possession from the lessee if any breach of condition is done by the lessee. Third, if there is a damage to the property which is leased, then the lessor having a right to recover the amount of damages from the lessee. Fourth, on the termination of the contract of the lease, the lessor having a right to take back his possession from the lessee. Now, moving towards liability of the lessor. Section 108, clause A. The lessor is bound to disclose the entire material defects relating to the property which is leased with the former intended use of which the former is and the latter is not aware. Section 108, clause B. Lessor is bound to request the lessee to put him in a possession of his property. Next, section 108, clause C says, lessor can make a contract with the lessee that if the pays the rent later on which is reserved by the lease and performs all the terms and conditions mentioned under the contract which binds the lessee, and then the lessee may hold the property during the specified time without interruption. Rights and liabilities of the lessee. Rights of the lessee prescribed under section 108 clause D onwards. Section 108D, during the continuing period of lease, if any accession is made, alleviation for the time being in the force, then that accession or area will be taken under such lease. Section 108E says, during the continuing period of lease, if the material part of the property is destroyed, wholly or partly, through by fire or by flood or by war or by violent act of the mob or by any other means, and it becomes permanently unfit for the use for which it is to be rendered, then it becomes void at the option of the lessee. However, if the injury is caused due to the default act of the lessee, then he cannot avail himself from the benefit of the provision. Section 108 clause F says, during the continuing period of lease, if the lessor avoids making any repairs to the property which he is obliged to do on a reasonable time, even after notice, and if such repairs is done by the lessee himself, then he has a right to deduct such expenses from the rent or can recover from the lessor. Section 108 clause G says, if the lessor avoids making any such payment which a lessor is bound to make, and if such payment is recoverable from the lessee or recovered against the property, then the lessee has a right to recover it from the lessor or can deduct it from the interest of the rent. Section 108H says, lessee having a right to remove all such things which he has attached himself to the earth, provided that lessee has to leave the property in such a state in which he has occupied. Section 108I says, when a lease is of such duration which is not specified by any means except the fault of the lessee, he or his legal representative having a right to collect all the crops which is planted, sown or growing by the lessee at the lease property, and they are free to ingress and egress from such property. Section 108J says, lessee having a right to transfer the property absolutely or any part of his interest by the way of sublease or through mortgage, but by such reason a lessee cannot by any means seizes himself from the liabilities which are attached to the leased property. Let us have glance towards the liabilities of the lessee towards the property or against the lessor. What liabilities are prescribed towards the lessor and property? Let us see. Section 108K says, a lessee is under obligation to disclose all the material facts which likely to increase the interest or the value which the lessee and the lessor is not aware about. Section 108L emphasize, lessee is under obligation to pay the premium or rent to the lessor or his agent on a reasonable time. Section 108 clause M says, lessee is under obligation to keep the property in a proper condition and on the termination of the lease, restore all such goods in such a way as it was at the time when he was in the possession. Further, section 108 clause N says, if a lessee is aware about any proceedings against the property or any encroachment or any interference is done, then the lessee is under obligation to give notice to the lessor. The lessee is duty bound to bring it to the notice of lessor. Section 108 clause O says, lessee having a right to use the asset or a goods which are placed in the property as ordinary prudence man and use it as it his own, but he is under obligation that he should not use or allow any other person to use the property in any other way or a purpose other than the purpose for the property is leased. Further, Section 108 Clause P express, lessee cannot without the consent of the lessor taken out any structure permanently of or on the property except in the case of agriculture purpose. Again, Section 108 Clause Q talks about on the termination of the lease, lessee is bound to give the possession back to the lessor. Friends, have a glance over the general legal differences between the lease and license, because in our society it is a big confusion. General people are not able to differentiate what is lease and what is license. So, here we are going to focus on the different points. The Transfer of Property Act 1882 defines lease. It is defined as a transfer of a immovable property for a specific amount of time for consideration, for which the transferee accepts the terms of the agreement. According to Section 52 of the Indian Easement Act of 1882, a license is a right granted by one person to another or to a specific number of persons to do or continue to do something in or on the grantor's immovable land. A second point of a differentiation, a lease is a transfer of an interest in a specific immovable property, while license is a bare permission without any transfer of an interest. The next point, a lease is both transferable and heritable. A subtenancy can be created by the tenant, and on the death of the tenancy can be inherited by his/her legal heirs. Whereas, in the case of license, license is neither transferable nor heritable. A license comes to an end with the death of either the grantor or the guarantee. A license comes to an end with the death of either the grantor or the grantee, since it is a personal contract, but a lease does not comes to an end on either the death of the grantor or the grantee. A license can be withdrawn at any time at the pleasure of the grantor, but the lease can come to an end only in accordance with the terms and conditions stipulated in the contract of tenancy agreement. A lessee has the right to protect the possession in his own right, whereas a licensee cannot defend his possession in his own name, as he does not have any proprietary right in the property. A lessee in possession of the property is entitled to any improvements or accessions made to the property, while a licensee is not. After above discussion, friends, we came to conclusion. Chapter 5th, Section 105 to 117 of Indian Transfer of Property Act deals with the lease. Lease plays an important role in the law of property. In this world, maximum number of the peoples will own a property, either their own property or enjoying someone's property by paying rent or premium. Thus, it is vital not only for the people in the law field, but also each and every citizen to have a good knowledge about lease, because at one point of time, every person will own a property. If a person enters into a lease agreement without knowing or without having decent knowledge about the lease, he or she may fail to have a proper lease agreement and they can easily be misguided. Lease is nothing but a contract between a lessor and a lessee for a specific period of time prescribed in the contract. There must be a clarity on the during of a lease, term of lease, amount to be paid, when and how it to be paid, etc. Violation of the rules, regulations, provisions and terms prescribed in the lease agreement is punishable under the law. Lease is a good thing until both the lessor and lessee does their duty well. Thus, from this session, we can have a basic idea about what is lease, who is lessor, who is lessee and their rights, liabilities and its kind. Thank you for watching this program.